It's always a pleasure to meet with the people at UCIP. It's a great organization, and I've been thrilled at the opportunity to work with UCIP and all of the people at the various counties throughout the state of Utah over the past years. I want to tell you a little story about something that happened a few years ago that kind of, I think, typifies the problems that you face in human resources and personnel management at the county level. I was asked by Washington County about 6 or 7 years ago to come down and do sexual harassment and discrimination training for all of their employees. That was from the county commissioners, the judges, all the way down to rank and file employees. And the sessions lasted about an hour and a half each, and we had some groups that were specifically designed for, or some presentations that were specifically designed for management individuals, and then we had another set of instructions for rank and file employees. And during one of those sessions, and like I said, they're pretty lengthy, and that's by design. I really wanted to create an atmosphere where people could feel like they could ask questions, kind of in a non-confrontational or safe environment, and also to really put them on the spot on some of the things that happen in the workplace. It's been my experience that that kind of intense training is appropriate and necessary at least every couple of years with employees, because I think, especially in the area that I know a lot about, discrimination and sexual harassment, people have a notion, they understand what they are supposed to do and what they're not supposed to do at work. But then time and time again, we find out that they have some real misconceptions, and that's part of a case that Julie Colby and I were just talking about. I represented Weber County in a case that literally went on for 10 plus years and involved 2 12-person jury trials in the federal district court here in Utah, 2 appeals to the 10th Circuit Court in Denver, not to mention the fact that it was scheduled actually for a 3rd trial, not involving Weber County, but involving the judge that had been accused of sexual harassment. So this was an extremely costly, time-consuming, and intense case. And one of the things that loomed large for me in that case was some of the misconceptions that the key players had about what policies and procedures the county had. And the policies and procedures were great. In writing, in the policy and procedures manual, they were very explicit about what an employee could and couldn't do, what a supervisor could and couldn't do. But this supervisor, this employee, and some of the other employees that were involved in that department had totally different ideas about what they could and couldn't do. Just as an example, the woman who brought the claim had also engaged in some behavior that all of you would recognize as being contrary to the sexual harassment policies and procedures in every county in the state of Utah. And when she was questioned about her own behavior, what she said was, well, that wasn't sexual harassment. And when asked why wasn't that sexual harassment, she said, well, nobody complained about it. Everybody seemed okay with it. And the behavior she was talking about, and Julie can attest to this, was pretty darn graphic and pretty darn over the top, including one example of, I won't give you the most graphic one, but including plastering a co-op worker's car with centerfolds from Playboy when he was about to get married. And she said, well, nobody said anything about it. Nobody complained about it. So it must have been okay. It wasn't contrary to the policy, which was shocking to me. The other thing that was really shocking to me, too, was the conduct of the judge in this situation, where he had written a mildly erotic poem about this particular employee and kept it in his desk at the office. Again, another total misconception about what the appropriate role was and whether or not keeping something like that at the office in the county's desk was private or not. And so there were some real issues there that needed to be addressed. And I think that this is a personal opinion on my part. It's been my experience in dealing with the cases for the various counties that if you just go and review the policy and have somebody check it off once a year, they don't get into the nitty-gritty of what specific behaviors are going to be considered sexual harassment. What behaviors are okay, what behaviors are not. So anyway, that's an aside. At some point during the discussion today, I'm sure Julie will jump in because she was, by the way, she was an excellent witness. She was excellent. It was like waltzing when she was on the stand. I could ask her a question and she would just take it exactly where it needed to go. And that's not always the case with witnesses. Sometimes they get on the stand and as a trial lawyer, you ask the question and you're just sitting there going, please don't say what I think you might say. You know, and sometimes they do, and of course you have to remain poker face. But the bottom line was, at the end of the day, with that particular case, we were able to completely exonerate the county from any wrongdoing whatsoever. But it took a lot of work and it took a lot of effort. So there's my first plug for education. Now back to the story about Washington County. So we're down in Washington County and I'm going through, you know, what constitutes sexual harassment, what constitutes discrimination, and all of those kinds of things. And bear in mind, this was about 6 or 8 years ago. And a woman raised her hand, and she was one of the librarians down in Washington County. And she said, I have a question. And I said, well, what is that? She said, we have a patron at the library who comes in frequently. And this individual identifies as a female, but is actually a male. She said this person was a transvestite. That's the way the terminology she used. And she said this individual uses the women's restroom, and we've received some complaints about it. What should we do? What are we supposed to do? And again, 6 or 8 years ago, I was totally taken aback. And most of the time in these sessions, people bring up questions that I haven't necessarily thought about before. A lot of them I have, but there are some times where questions come up and I am a little bit dumbfounded, not quite sure what to do. And in that situation, I had to kind of sit back and I said, you know what, I really don't have a good answer for you at this point in time. I'll need to do some research. And of course, I did some research and I found nothing in Utah law that really specifically addressed that issue. There was really nothing on a national level either at that point in time in our history. But of course, as we know, times have changed. And Utah addressed this issue in 2015, and we'll talk a little bit more about that when we get into some recent developments and some of the important laws that you deal with on a day-to-day basis in your capacities. But I wanted to bring up a case that I think demonstrates how what you do is somewhat of a moving target. You know, things are fluid. Things change based on court decisions, based on what legislatures do, based on county ordinances and so on and so forth. And this case I want to just mention to you deals with that issue that I just mentioned down in Washington County. There was a gentleman by the name of Gavin Grimm. He was a student at a county high school in Virginia. And this also demonstrates how cases take forever to get resolved. So I just mentioned this to you as well. And this person, gender identified as a male. And he wanted to be allowed to use the boys' restroom in the school. He wanted to be able to use the boys' locker room in the school and wanted to be able to continue to identify as a male. Originally, the school looked at the issue and decided that it would be okay for him to do that. And so he went about doing that. Well, a group of parents got very upset about it and actually went to the school board and got the school board to adopt a rule and regulation that said no, the person had to use the restroom and locker room based on their biological sex. The ACLU got involved in this matter and actually brought a case against the school board in October of 2014. I think this was a relatively new issue as of that point in time. Actually, that's when the student was allowed to do this. And it was actually December of 2014 when the school board voted 6-1 to institute this policy. On June 11th of 2015, the ACLU files its lawsuit against the school board in federal court, arguing that the board's policy violated both Title IX and the 14th Amendment. June 30th of 2015, the U.S. Department of Justice officially backs Grimm in his suit, citing guidance given to schools on how best to accommodate transgender students by the Barack Obama White House. On July 27th, 2015, the judge of the U.S. District Court for the Eastern District of Virginia grants a motion to dismiss Grimm's Title IX complaint filed by the school board and denies Grimm's request the preliminary injunction be put in place to stop the school board from what it's doing. On October 25th, 2015, the ACLU files an appeal in the Fourth Circuit Court of Appeals. April 19th, 2016, so now we're nearly 2 years after this initially came to be an issue. The Fourth Circuit overturns the judge's decision and reinstates the policies that were and the guidance that had been given by the Obama White House. At this point in time, then what happens is that the school board appeals that decision, and it goes to the circuit court. Circuit court backs and affirms the decision of the district court, and then there's an appeal filed with the U.S. Supreme Court on August 3rd of 2016. The U.S. Supreme Court grants review and schedules arguments for March 28th of 2017. On February 22nd of 2017, the Trump administration revokes the guidance previously promulgated by the Obama administration regarding accommodations for transgender students. March 6th of 2017, citing the revocation, the U.S. Supreme Court issues an order vacating its decision to review the case and remands it back to the Fourth Circuit Court for further consideration. The Fourth Circuit Court subsequently reviews it and refers it back to the district court to be for further adjudication. At this point in time, now we're into 2018. This matter has been scheduled for trial, beginning for a jury, 12-person jury, beginning July 23rd of 2019. And you can bet that this particular case will then be, regardless of the outcome, will be appealed to the circuit court and will be appealed to the United States Supreme Court. So it will get kicked back up and then probably kicked back down. So that's just a demonstration of how these things really can change through the years. But as I mentioned, Utah addressed that issue actually in 2015. We'll see if there's anything that results from that. I also wanted to mention to you that I brought several different documents for you that hopefully will be somewhat helpful. The first is the outline of some of the cases and some of the decisions and some of the laws that I want to talk with you about today. As I was preparing for this, the stack of different Utah laws that apply to the employment situation is vast, and so I tried to limit it to some that have been recently modified through amendments by the Utah State Legislature or recently adopted by the Utah State Legislature, as well as some other interesting issues that I thought had come up in recent years. And so that's what that document is. I also brought along an outline that I did several years ago, dealing specifically with the discrimination laws. And though there's been some modification and obviously some updates through case decisions, that is really a good primer on some of the discrimination laws. And I know that you all know quite a bit about the discrimination laws, but we will talk about them somewhat here today as well. Then the final document that I brought for you is a workers' compensation overview that we do in our office and provide to our clients. We have a number of clients that we do employment law for, and so this is something that we provide to them, and I thought it might be helpful and useful to you. It was interesting to hear the last speaker's presentation because it brought to mind something that I dealt with just yesterday for another employer that I do work for. It's actually a nonprofit organization, and it is, I'm curious to get your impressions of this. This involved an employee who has worked for this organization for a number of years as a truck driver. He has suffered a number of on-the-job injuries, and most recently suffered an injury to one of his shoulders. He had previous injuries to his other shoulder. The truck driver involved in this situation goes and picks up donations to this organization, and it's a one-person on the truck situation. So he has to get out and, get the bags and the things into the back of the truck, and then he has to unload it wherever it's going to be taken. And there's no predicting how heavy or big or awkward those bags or that other material may be. And when he injured his shoulder this last time, the employer tried to do some reasonable accommodation to allow him some time to heal, and put another individual on the truck with him to do the lifting and throwing and everything. Obviously, that was costly to this organization. That's really on a shoestring budget. The gentleman then had to go in for surgery last November. He's been off of work since last November, and he recently got what was called a full release to return to work with no restrictions. However, that didn't seem very likely in light of some of these circumstances with him. And so through the Workers' Compensation Fund, we asked the claims adjuster to go back to the doctor that they had appointed to work with this gentleman and tell us, based on that job description that we were talking about, how important those job descriptions are. Based on this job description, do you really think this gentleman can have a full release? And the doctor came back and said in a very cryptic way, modified work duties can return to truck driving if assistant is provided, or partner is provided, something like that. And so then the question was that something we had to do? We had to look at FMLA, we had to look at ADA, we had to look at workers' compensation. And so I'm just curious, do any of you have any sense of what we should do in that situation? What about FMLA? Do you think that FMLA applied? He'd been off work since last November. So he'd been off for more than 12 weeks. So we did not feel like there was a FMLA situation. Does anybody look at that differently? Okay. And then with the workers' compensation situation, as Blake was explaining, one of the motivations is to try to get these people back to work. And I'm all on board with that. But what do you do in a situation like this where this man has had 2 serious injuries to shoulders, and he can't do the lifting, he can't do the unloading? Is it reasonable to put him back on the truck? Say no. Yeah, and is it a reasonable accommodation for the employer to to have to provide a partner for him to do that. Oh, good, you all agree with what I told him. And now, yeah.
I was just going to ask, given he's a truck driver and you talked about essential job duties, what's the percentage of those that he can't do?
That's an interesting question. I mean, he certainly can drive a truck, but one of the concerns was, you know, you have to get in and out of that truck repeatedly through the day. So that's grabbing on, pulling yourself up. And always what comes into play, what's the role of the employer in making an assessment of that? I think our role has to be somewhat limited. We have to rely on, you know, the doctors. We have to rely on voc rehab people to tell us that. The other thing is what weight could he lift? You know, certainly he could probably drive the truck, but these other things that were essential functions of the job, he could not do, even with the proposed accommodation that we had to give, that he was in essence asking us to do. The other thing that came into play, and this is something that's important, and I know that this is not totally on our topic, but there was some recent court decisions that basically said that having someone on leave for an extended period of time is not a reasonable accommodation. You can do that for a short period of time. Talking about doing some sort of reasonable accommodation that would in essence require us to have another full-time employee work with him side by side is not a reasonable accommodation. And there's some case law that supported us in that. And finally, under workers' compensation, do we have to keep that truck driving position open for him when he goes out on a work-related injury? Johnny's shaking his head no, and I trust Johnny. That's true. Yeah, we don't have to keep that position open and available for him. And as a matter of fact, in the meantime, we determined that we needed just a part-time truck driver, and we have a part-time truck driver that filled that position several months ago. So what do we do in a situation like this? Do we just say, sorry, we can't bring you back? Or do we look for, what did he call it? Not light duty?
Temporary modified.
Temporary modified. Well, in essence, what we decided to do was to offer him a position as a telephone solicitor for the organization, which would comport with all of his restriction, well, the restriction that the doctor gave us that really wasn't very helpful when it came to some of these things. You know, and this is a doctor that specializes in doing these things, but it wasn't helpful to us. And I put myself in this category as the employer because, you know, we don't know how much weight he can lift. We don't know how many times he can do it. We don't know if he can lift above his head. We don't know if he can climb in and out of the truck multiple times every day and climb into the back of the truck multiple times every day. So I think that it's in all of our best interest to, when working with the comp carrier, when making the assessment for ADA, when looking at MLA and all of those kinds of things, to get that kind of specific information that we want. You know, we can't necessarily get behind the diagnosis or behind the medical care and treatment, but we can certainly find out, can he do these essential functions of the job? I don't know if I could really put a percentage on that, but anyway, so with all that said, I'm going to tell you that this is sort of a scattershot approach to some of these things that have been going on in the employment area in the state of Utah. So I'm going to go through these, and please feel free to jump in and add any comments, questions, or concerns, because like I said, there were so many things that were happening here. One of the things that passed the legislature this past session, emergency services volunteer employment protection, and that's the first one that is on the outline that I provided to you, and I've also provided the code sections that hopefully will help you find these if you need to. This particular act prohibits employers, including public employers, from terminating an employee for being an emergency service volunteer. Employers are prohibited from disciplining or terminating or in any way doing any kind of adverse job action against an employee for either being late or missing work due to their service as an emergency volunteer worker. And the employers can request that there be written verification that the employee was actually involved in the emergency. Employees can be docked pay for the time that they missed, but they cannot be otherwise penalized. I don't know if all of you were aware of that, but that's something that I think is important and just passed this in 2019. Another change that I thought was really important to take a look at, and you may want to look at some of these acts in more detail at some point in time, was the expungement changes to the Utah Code. Are any of you aware of these changes? This is something, okay. It prohibits public employers, again, from inquiring into an applicant's expunged criminal history, except in certain circumstances. It permits an applicant to answer a question related to an expunged criminal record as though the criminal act never happened. So, of course, you know, that's if the act is the criminal conviction has been expunged from the record. But it goes on, which I think is really interesting. A public employer may not exclude an applicant from an initial interview because of a past criminal conviction. And that's whether it's been expunged or not. The public employer excludes an applicant from the initial interview if A, it requires the applicant to disclose a criminal conviction on an application form for employment. And I know that for as long as I've been practicing law, I've been telling people you can ask for felony convictions and things like that. But what this law is basically telling us is that we can't do that on the application form. As I read this law, and I'll continue on with some of the other criteria, the way I interpret it, I think the legislature was saying, let's at least give these people an opportunity to come in for an initial interview. So I think that's the purpose of it. It requires that the applicant, okay, let's see, where was I? It's considered, okay, sorry. The public employer excludes an applicant from the initial interview if it requires an applicant to disclose a criminal conviction on the application form. It requires an applicant to disclose a criminal conviction before the initial interview. If no interview is conducted at all, then that is considered to be excluding this individual because of the criminal history. So if before this conditional offer of employment, you're really in kind of a binder. The important thing to keep in mind, however, a public employer may ask about criminal convictions during an initial interview and consider it when making a hiring decision. So in other words, you call the person in, ask them about criminal history. Obviously, they don't have to tell you about criminal history if their record has been expunged, but if they do have criminal history, you can ask about it in that initial interview, and then you can take that into consideration as to whether or not you're going to hire this individual. There's some exceptions to this law, and they're fairly logical exceptions. You can ask these questions earlier on in the process before the initial interview if it's mandated by some other law. If it's a law enforcement job, a criminal or juvenile justice system job, non-employee volunteer positions, jobs with children or vulnerable adults, jobs with the Department of Alcohol Beverage Control, the State Tax Commission, or jobs that deal with financial or fiduciary functions. So in those situations, you can find out about criminal history in advance. I'm not going to spend any time on the Medical Cannabis Act because I think you have another speaker that spent a lot of time. I just included it there because I think it's going to create a lot of interesting issues for employers going down the road. We'll see how that all shakes out. There were some amendments made to the Utah Protection and Public Employees Act, or the Utah Whistleblower Statute. which I think is kind of a confusing statute anyway. It was part of our case up in Weber County. I was a little bit surprised by some of the judge's rulings when it came to this, because in our case, what the individual counted as reporting some sort of waste or abuse or whatever constituted of her going to the press and making her allegations against the county and the judge. And I didn't think that was really what was supposed to happen. Obviously, that might be a First Amendment issue, and we did have First Amendment issues involved in that case. But the amendments to this act and the act itself prohibits public employers from taking adverse actions or retaliating against an employee when the employee or someone acting in his or her behalf communicates in good faith, which is always an issue that you have to try to establish, the waste or misuse of public funds, property, or manpower, a violation or suspected violation of the law, rule, or regulations adopted under the laws of the state of Utah, a political subdivision of the state, or any recognized entity of the United States by a state public employer that amounts to gross mismanagement, abuse of authority, or unethical conduct. The amendments that were passed in this past session of the legislature include certain exemptions from Utah's Governmental Immunity Act requirements if it's a whistleblower claim. The amendments also call for the creation of an independent personnel board to hear complaints in higher education. That's exclusively in higher education. They carved that out. There is a statute of limitations to bring these complaints of 180 days. The time for filing can be extended, and this is the new part. If the employee originally brought the complaint timely, but it was dismissed without prejudice and not on the merits, then they can have another 180 days to refile it. So that's a little bit of a tricky issue there. Utah Anti-Discrimination Act and amendments. There's been some amendments to our Utah Anti-Discrimination Act, and I want to talk briefly about this act. The UADA applies to most employers who have 15 or more employees, including public employers in the state of Utah. It prohibits discrimination, including harassment on the basis of race, color, sex, pregnancy, childbirth, pregnancy-related conditions, age over 40, religion, national origin, disability, and the new language that was added in 2015, sexual orientation and gender identity. Most of these laws that we're talking about prohibit retaliation if somebody brings a claim under these specific laws. And I think many of you are aware that the vast majority of the claims that are filed with UALD as well as the EEOC involve claims for retaliation. The underlying claim of discrimination or violation of the law usually, may not be meritorious, it may not have any teeth to it whatsoever, but then the employee may have a really great retaliation claim. So again, another place where education is absolutely vital with your management staff and actually as well as your other employees. No retaliation whatsoever if somebody brings a claim, or if they have heard somebody might bring a claim. We have to treat them exactly as we would treat them but for the complaint. So that's really important. And most of the ones, the cases that I'm involved in have also included claims for retaliation. And our case with Julie, sorry Julie, I keep coming. But our case involved a claim of retaliation. The employee's claim was that we eliminated that entire justice court in order to eliminate her job for filing a claim. I never understood how that moved as far as it did. The jury didn't buy it at all, but for some odd reason the court kept it alive. We went through the entire trial twice. So keep that in mind. Emphasize that constantly with your employees. And No gossip around the water cooler, no comments about it at all. It should not be mentioned, and everybody should treat each other with courtesy, dignity, and respect, and ignore any claim. The act also prohibits any person from aiding, and it's any person. This is inside, outside of the employment. It doesn't necessarily have to be the employer. It can be a coworker. It prohibits any person from aiding, inciting, compelling, or coercing any act prohibited by the act. It applies to employment agencies and labor unions as well. Requires employers to provide reasonable accommodation for employees related to pregnancy, childbirth, breastfeeding, or related conditions. And I think that's important if requested by the employee, unless it would cause unreasonable hardship on the operation of the business. The Act also requires employers to post in a conspicuous place and in the handbook the employee's rights under UADA, including the rights to reasonable accommodations. And of course, this dovetails with the federal laws as well, so it's important to keep on top of the federal cases as they come down, and to also look at the EEOC actions. Requires employers to make reasonable accommodations regarding dress and grooming policies, as well as for set-specific facilities, again, including restrooms, locker rooms, showers, and dressing rooms based on gender identity. So the Utah law has actually gone further than many of the other states in the union at this point in time. And also, this is contrary to the interpretation of the federal law by the current administration, and specifically by former Attorney General Jeff Sessions. So this is still going to be an area where there's going to be a lot of litigation going forward, I'm confident. The Utah Anti-Discrimination Act does not specifically address reasonable accommodations for religious practices. However, the Act does protect an employee's right to express religious beliefs in the workplace in a reasonable, non-disruptive, and non-harassing way. So here we're balancing discrimination laws against First Amendment rights, and so you have to kind of do that. It has to be a reasonable expression of religion or religious beliefs. An employer that I do a lot of work for, it's a major utility in the state of Utah, one of the attorneys had this statue about this high of Jesus Christ in their office. And we had to kind of gently remind that person that that's probably not that kind of modest expression of religious beliefs. Or, wearing a cross, or, talking a little bit about your religion, not necessarily proselytizing. This gets to be real dicey because it's certainly an issue that we encounter periodically in the state of Utah. So the courts basically told us that, these kind of reasonable expressions are allowed, and people are entitled to their First Amendment rights even in the workplace, but not if it's over the top or really extreme or, whatever. So it's a judgment call in many respects. When we're talking about reasonable accommodations for religious practices, there are cases that talk about, of course, making a reasonable accommodation for an individual if it doesn't totally disrupt, or if it doesn't disrupt the business operation, if they have some religious day that they need to be off of work, or if they're sacred, or their days of worship are Friday, Saturday, as in the Jewish religion. And if you can make a reasonable accommodation for them, then you should do it. If it's a very small mom and pop operation, you may not be able to do it. Same for some employers that, of course, have their businesses open on Sundays, and that is a day of worship for some other religions. Obviously, if you can accommodate that individual, then you should do it, as long as it's not totally disruptive to the business. Some cases have come up where there was a discussion whether the employer needs to make available a place for a Muslim to do their daily prayers. And I've seen contradictory opinions on that score. So the Utah law doesn't really address that specific kind of an issue, so we may see how that plays out in the future. There have been some cases that I'm aware of where, talking about a headscarf, where that's, if that's something that is mandated by an individual's religion, then the employer needs